Okay, so this chapter we're covering Chapter 11, Assault, Battery, and Other Crimes Against Persons, in addition to our Blue Book, Armed Criminal Action, and Offenses Against Family. We're going to cover some other material in our lecture this week, in addition to those Blue Book chapters. So I've provided you some links to those to work your way through that. Our textbook goes along with our Blue Book fairly well, but again, you will need to read through and look at the other statutes as we go. So, vocabulary, we're going to look at our statute on assault, and it's broken down for us in Chapter 565. And first thing you'll notice that we have 4 different degrees of assault, and then we have domestic assault. We'll get to domestics here shortly. But when we start looking at the actual statute, so assault in the first degree, a person commits the offense of assault in the first degree if he or she attempts to kill or knowingly causes or attempts to cause serious physical injury. There knowingly is our culpable mental state when we start looking at that statute. Second degree, a little bit lower, attempts to kill or knowingly cause or attempts to cause serious physical injury to another person under the influence of sudden passion. That's one of the words that we're going to look at. Arising out of adequate cause. Now, one of the things about second degree that you want to look at is here we've got that lower culpable mental state of recklessly on that second degree. If a person recklessly causes serious physical injury to another person or recklessly causes physical injury to another person by means of discharging a firearm. Those are, like I say, lower culpable mental states. For assault in the third degree, the person commits the offense of assault in the third degree if they knowingly cause physical injury to another person. It doesn't say serious physical injury. So any injury right here is going to fall under that third degree. And you'll notice that when we start looking at this, it's still a felony. The offense of assault in the third degree is a Class E felony. Assault in the fourth degree is where we get into what we probably classify as simple assault, depending on where you live. So the person attempts to cause or recklessly causes physical injury, physical pain, or illness to another person. With criminal negligence, causes physical injury to another person by means of a firearm. Criminal negligence being the lowest culpable mental state. So if somebody says, this was an accident, well, we know it's a firearm. You should have been, there was a risk and you didn't take that into account and you caused an injury. The person purposely places another person in apprehension of immediate physical injury. Recklessly engages in conduct which creates a substantial risk of death or serious. Person knowingly causes or attempts to cause physical contact with a person with a disability. The person knowingly causes physical contact with another person, knowing the other person will regard the contact as offensive or provocative. So this line right here, there doesn't have to be an injury. That physical contact where the other person is going to take offense or maybe made in a sexual overtone, that's definitely something that we can start looking at as a fourth degree assault. There's some other statutes we'll talk about later that we can use too. So, in a lot of cases, like we just read, assault is an attempt to commit a battery. We don't actually have to have a battery. We looked at fourth degree assault and we just placed somebody in apprehension, where battery is actually the successful assault. So, when we start looking at that, that's definitely something we want to take into account. Now, Missouri has battery and assault all under the assault statute. Offensive touching, unpermitted physical contact with another person, we just read that in that fourth degree assault. Menacing, intentionally placing or attempting to place another in fear of immediate serious physical injury. Aggravated assault involves a firearm or some type of a weapon. Aggravated battery causes serious bodily injury is committed with a deadly weapon. Mayhem and malicious disfigurement, willfully inflicting injury on another person. Again, all of these for us fall under that assault statute. Kidnapping, false imprisonment coupled with movement of the victim. Kidnapping usually requires some type of a movement. Hostage taking, use or threat of use of force to restrain or confine a person. Hostage taking and kidnapping are different in that hostage taking, the person is not normally moved. False imprisonment, unlawful restraint of another person. An assault conviction requires the act of intending to cause bodily injury or instill such fear. Using a weapon to cause fear is an assault. So if you threaten somebody with a weapon, whether you use it or not, it's going to fall under that assault. Battery, conviction requires intentional infliction of bodily harm or unlawful touching in a rude or offensive manner. And this is interesting right here, the rudeness when we get into that. And we're going to talk about that a little bit more. There's an actual statute out of the state of Kansas that talks about that one. An assault or battery becomes aggravated if a weapon is involved. And we start adding extra crimes if a weapon's involved. So assault is defined differently in different jurisdictions, but the following types of assault statutes are most common. Assault is an attempted battery. Assault is an intent to cause apprehension of immediate bodily harm. We just read that. Assault is an attempted battery with present ability to commit the battery. So can the person actually do what they say they're going to do? If a person calls you on the phone and says, I'm going to hit you in the nose, they really don't have the present ability. But if they're standing right in front of you and say the same thing, definitely they have present ability. Now, we talked about assault a minute ago in that we could have different statutes that covered basically the same thing. And what I want to do is look at peace disturbance and let you see that. So when we look at peace disturbance, comparing it to that assault statute, a person commits the offense of peace disturbance if he or she unreasonably knowingly disturbs or alarms another person by loud noise, offensive language addressed in a face-to-face manner, threatening to commit a felony. So there is, very close to what we're reading by putting somebody in apprehension, fighting, creating a noxious or offensive odor in a public place or private property without consent, and purposely inconvenience another person by unreasonably physically obstructing. So whether they're vehicular or pedestrian traffic, free ingress or egress from a public or private place. So basically blocking them from going to where they want to go. So when we start looking at assault statutes, peace disturbance can in a lot of cases be a precursor offense to what later on might turn into an assault. At the same time, harassment is another one of those offenses that fall really closely when we get in to start working with our assault statutes. A person commits the offense of harassment in the first degree if he or she without good cause engages in any act with the purpose to cause emotional distress to another person, and such act does cause such person emotional distress. Now this is first degree. Second degree, when we start looking at harassment, basically it does cause emotional distress, but it's just the attempt of it can actually get that second degree charge. Now, you have to look up, what emotional distress is, and it's pretty specific when we start looking that up. The biggest thing to remember when we start talking about crimes is a lot of times there's other statutes that are very similar that may be a better statute to start looking at as far as, writing your report and criminal violations. So, codifying the common assault law, for an offense to constitute assault, the victim must ordinarily be in apprehension of impending harm or danger. If somebody comes up and, says, I hit them, and you ask why, and they say, well, they were threatening to hit me, well, were you in fear is going to be that, the next question that I'm going to be asking. Doesn't, automatically require it, but I want to know, were you in apprehension? So, attempted battery requires proof of intent to cause physical injury, and then intent to create that apprehension. And the easiest way to explain apprehension is what I call a flinch response. So if somebody draws back and you flinch, or you see another person flinch, that to me is a pretty good example of apprehension. And there's better ones, but that easily explains it and lets you get a picture in your mind of what it's going to be. Present ability, like we talked about before, can the person really do what they're saying they're going to do? So aggravated assault, basically what we're looking at here is, how bad was the assault? Were there any weapons involved? So weapons are going to add a whole different realm to that criminal violation. So assaults become aggravated when they are committed with a firearm, are part of intent to commit a felony. So battery, virtually any kind of physical contact can constitute a battery. We looked at that a minute ago. Some states make it a battery to touch another offensively. Our statute uses the word provocatively. Some states do not require a guilty mind in order to constitute battery. So some states have made this a strict liability crime. In serious bodily injury results, or if a weapon is used, it's aggravated battery. So sometimes other circumstances, such as a victim being pregnant, make a battery aggravated, or if they're a special victim. So battery defenses, self-defense. I was defending myself as long as you weren't, involved in that assault initially. As far as instigating it, the conduct was necessary and lawful to prevent escape. The other party consented with the rules of sport being played. Think about boxing, mixed martial arts. Definitely we have, batteries going on there, but at the same time, they're part of that sport. Conduct was necessary to prevent a suicide. Somebody's threatening themselves with a weapon and you wrestle that weapon away from them. You've looked at an assault by statute, but at the same time, you've done it to protect them. Reasonable discipline of a child, including spanking. If you were to spank an adult it would definitely be under that assault statute. In offensive touching, battery, the touching was accidental or consented to. So somebody touched somebody in a way that would normally be provocative or offensive, but it was done out of accident, say they fell or something like that, and there's no intent. In some cases, the original offender can become the victim, and we start looking at this with defensive persons. And like I talked about a second ago, if the actor was the initial aggressor, except in such cases his or her use of force is nevertheless justifiable, we start looking at this. Was the person that's claiming that defense the initial aggressor? And though we're not going to cover the entire statute, there are a few parts of this that you really need to look at and then go back and read the entire thing yourself. But they reasonably believe if it's deadly force necessary to protect himself or herself or an unborn child against death, serious physical injury. And then we go on down, it starts talking about the castle doctrine. So a person does not have a duty to retreat from a dwelling, residence, or vehicle, or the person is not unlawfully entering from private property is owned or leased, if the person in any other location such person has the right to be. And the justification afforded by this section extends the use of physical restraint as a protective force, provided that the actor takes all reasonable measures to terminate the restraint as soon as reasonably possible. So let's say you find a burglar in your home and you hold them down until you call the police. That's what this is what they're talking about right here. Right, offensive touching obviously is going to fall under that sexual assault statutes in the same realm as far as what they're doing when we start looking at those sexual assault statutes. Generally provide for 3 or 4 degrees of sexual assault, and these statutes also forbid and punish offensive touching. Sports injuries, like we talked about a little bit ago, football, boxing, mixed martial arts, where there's rules and a referee, that's where we start looking at, yes, a person under the law could have committed what would be an assault, but based on how they were doing it and following the rules with a referee, that's where it comes into play. And we can look at that under our statutes when it starts talking about, an amateur competes in boxing, wrestling, kickboxing, full contact karate, what a bout is, what boxing is, combative fighting. Combative fighting is the one that you go to somebody's backyard and they are out there fighting, but there is no referee. That's where we can get into some issues that this was not a sanctioned event. Contestant, but you can follow all through these and actually start looking at, okay, what is assault, what is not an assault, and why. And it's very specific when we start reading our statutes about what can be done and what can't be done. So other physical contact without consent, pushing, pinching, biting, scratching, any of these things that we start looking at that could, in the right circumstances, be committed, looked at upon an assault. If such contacts aren't physical, not physical, but intentional, they were an accident, that could be a defense to that. It's shown that the conduct provoked or tended to provoke a disturbance or disorder. We talked about peace disturbance. That's what we fall under versus disorderly conduct. So felonious and aggravated assaults and batteries, all states have the aggravated assault. Again, when we start looking at that, we're talking about the use of a weapon. So, or somebody was seriously injured, or they were a special victim, depending on what state and what your statute says. So menacing laws, again, we don't have that specifically to our state, but it would fall under our assault statutes, typically defined as intentionally placing or attempting to place another in fear. So that would be our 4th degree assault statute if we were reading that. Now, one thing about statutes is they can change. So, what may be this year's 4th degree assault may next year change to a 3rd degree assault, depending on how the legislature wants to look at that. 2017, Missouri did have quite a few laws change, and our laws were moved around just a little bit. So mayhem and malicious disfigurement, willful infliction of an injury to another person. So when we start looking at that again, it would fall under our assault statute. Other states do not include mayhem as a separate crime. That's us as far as what we were talking about just a second ago. So hate crime laws, states may enact crimes that increase the penalty if a person was picked because of, their race, religion, disability, sexual orientation. Something to that effect was the reason that they were chosen to be a victim of this crime. The state has to prove that the victim was a substantial factor. As far as when we were looking at these criteria, is that what caused this assault? And when we start looking at our statutes, when it starts talking about for all violations for 565, it starts some enhancement, which states believe knowingly motivated because of race, color, religion, national origin, sex, sexual orientation, or disability of the victim, the state may charge the offense or offenses on this section as a hate offense, and it's a Class D felony. So Missouri does have our hate crime statute. Depending on where you work or what jurisdiction you work with, they may be worded just a little bit different. So child abuse and neglect, something that I'm kind of close to. I worked a lot of child abuse and neglect calls over the years, and we feel for these children on a pretty deep level. People inflict injuries to children. They are charged with murder, assault, battery, child abuse, child neglect, endangering the welfare of a child, depending on what the code of that state says. And you're going to have to get pretty good at reading these criminal codes and figuring out the best one for your particular case. So Chapter 568, when we start looking at this, and again, we're going to cover more of these later on, but these are our crimes and punishments against family, and this is where we get into endangering the welfare of a child and abuse and neglect. And these statutes are just a little bit different. A person commits the offense of endangering the welfare of a child in the 1st degree, knowingly acts in a manner that creates a substantial risk to the life, body, or health of a person less than 17 years of age. And then you can read through that, but that 17-year-old, less than 17 for us is what that is right now, and that may change. It may change to less than 18 in 2021. So, 2nd degree, a person commits the offense of endangering the welfare of a child in 2nd degree with criminal negligence, acts in a manner that creates substantial risk to life, body, or health of the child. So, as an example, somebody is intoxicated to the point they obviously shouldn't be operating a motor vehicle, and they place their 5-year-old in the car next to them, no car seat, no anything like that. You pull them over as an officer, or worse, they become involved in a traffic crash, and you may look at this endangering the welfare of a child as another charge that you would go through just by their actions. Being a parent or guardian or other person legally charged with the care of the less than 17 recklessly fails or refuses to exercise reasonable diligence, care, or control of such child to prevent them from becoming provisions of basically the chapters that we start talking right here. And that's the juvenile court for that point. So somebody that has decided that they aren't going to follow and keep that child protected. So this is a good statute to use if you're working with children that have been abused and neglected, to help you through that. Obviously, talking to your prosecutor is going to help even more. Some of you are going into social services, and being familiar with these can help be very helpful. Abuse and neglect, basically these are describing what those actually are. So what is serious emotional injury? Well, an injury that creates a substantial risk of temporary or permanent medical or psychological damage. And you can read through these as you go through. Genital mutilation, unlawful transaction with a child. This is interesting. It sounds like a sexual offense, but reality is it was based off pawnbroker, junk dealer dealing with children as far as who can, pawn different things. Where I would use it is knowingly permits a minor child to enter or remain in a place where illegal activity and controlled substances. So it's kind of in an odd place as far as looking up a statute, but if you have a house where there's a lot of illegal activity going on, and the parents knowingly let that child enter or remain in that place, you could actually use this unlawful transaction with a child statute. Trafficking in children, and other statutes that you can follow up as you work your way through the RSMO on the child cases. But active physically hurting a child, passive failure to care for a child, again, that's our neglect charge. It's also a crime to expose a child to sexually harmful material. Most states have a duty to report suspected abuse. You guys are going into a field in criminal justice that you're almost obviously going to be what's called a mandated reporter. So when we start looking at kidnapping, according to your text, kidnapping was not frequently a charged crime under Old English common law, but became a serious felony in American states. Carrying away, used to be, quite a distance. Now we look at it as if I take you from a point where you want to be to a point that you don't want to be, we can start looking at that kidnapping statute. Now our kidnapping statute falls under Chapter 565, offenses against person. And you notice this is a very large chapter when we start looking at these. But right underneath harassment, we have kidnapping, and we have different degrees of kidnapping. So we have kidnapping first degree, child kidnapping, kidnapping second degree, kidnapping third degree, defenses to kidnapping. Basically all these. One of the ones I want to look at though is kidnapping third degree. We used to have a statute called felonious restraint, and that went away, and we added kidnapping third degree. So a person commits the offense of kidnapping third degree if they knowingly restrain another unlawfully and without consent so as to interfere substantially with his or her liberty. So this could actually be a case where we had a couple break up. One party goes over to the other one's house and they want to leave, and one party says, no, you're not going anywhere. Just by threat, they could be restrained in that they were afraid to confront the other person. Or it could be even worse. They could tie them up or different things like that. And it could actually, go into a second degree. A person commits the offense of second degree, knowingly restrains another unlawfully and without consent so as to interfere substantially with his or her liberty and expose him to a substantial risk of serious physical injury. So somebody ties him up and threatens to injure him. But we don't actually talk about moving a person with that third degree and that second degree, like your book talks about. Again, you can read the rest of the statutes. I've provided the link for you. Most states require the kidnapped victim be moved. Generally, the movement must be substantial. But again, reading our statutes, that's not always the case. So, offense against the liberty of person kidnapping, criminal purposes kidnapping, movement is rarely a problem today. And you looked at that. So, most courts hold, in order to do so, some movement, not merely incident to other crime, is necessary. Moving a teller from the front to the back of the bank being robbed is not enough to constitute kidnapping. But, based off the example again in your text, moving a rape victim to a place not visible from the roadway is enough to constitute that kidnapping. So, kidnapping by confinement, we just looked at that, and that's the old felonious restraint, putting that person in a place of isolation for a substantial period, but the period can vary. Victim held at knife point in a bathroom for a few minutes to prevent him or her from responding to a police officer is sufficient. So officer's knocking on the door and somebody's not letting that person come through threat of violence. Hostage taking, we talked about this right at the start of this lecture, in that hostage taking usually doesn't require any type of movement. So they're just being held against their will as far as that goes. In a lot of cases, ransom, they want to escape, something to that effect can fall into play there. So, use of force by law enforcement, a police officer's defense to an assault and battery charge could be that the conduct was necessary and lawful. Now, based off what's going on over the last few years as far as use of force. You need to be very cautious with this if you're going into the law enforcement field. And as a citizen, we need to make sure that we're paying attention to what our officers do and that they are following the law. So, but we can use force when necessary to prevent an escape of person in lawful custody, when necessary to lawfully detain or hold a person, and in the accomplishment of a lawful arrest. So when we start looking at our statute, it's very specific as far as when we can use force. One thing about use of force in making an arrest is at the point the person complies, that force stops. We are talking more and more these days about de-escalation instead of using force, trying to use alternative means to maybe calm that person down and slow that situation instead of immediately going to a physical act. So, discussion, man grabs a woman, pulls her out of a car to the side of the road, pounds some bushes and rapes her. What charges might a prosecutor bring? Now, we've talked about that. Definitely we have an assault, we have the rape. Depending on the example we used a minute ago, we could have that kidnapping. So, false imprisonment, again, the old felonious restraint charge. We would look at that under our kidnapping statutes now. Defendant had no lawful authority to confine or restrain the person. So, most states using the term are interpreted to exclude brief detentions in situations like a shoplifter, teachers detaining children. There is statutes that protect us as far as, people that do loss prevention, educators working with children. And the other situations that we run into is that, interference with custody, parental kidnapping, that we can start looking up those statutes and saying that, this may fall under that statute without it being a stranger that participated in, taking that child someplace that they were not supposed to be. And then if the child wanted to go, but the other parent had no authority, it could still fall under the parental kidnapping or interference with custody. So, thousands of children disappear each year. Although the offending parent may state that he or she seeks to protect the child's welfare, other motives for child snatching exist. We don't call it child snatching. Again, we fall under that interference with custody. Most states are generally prepared to extradite the offending parent back to the state. As far as family violence goes, in addition to taking children, we start looking at domestic violence, and we did just a minute ago, as far as those different degrees. But family members usually include spouses, persons living together with parents and children, or a person from whom a defendant has had a child. As always, I would encourage you to look up all the definitions, because what we would consider from our local area to be a family member may not actually be what the statute says. So we don't want to ever assume. Always look up your vocabulary as far as the law goes. So in Missouri, a family or household member is a spouse, former spouse, any person related by blood, marriage, persons who are presently residing together or have resided together in the past. You notice right here, it does not say anything about a relationship. All it says is presently residing together. Any person who is or has been in a continuing social relationship of romantic or intimate nature with the victim, and anyone who has a child in common regardless of whether they've been married or have resided together in the past. Again, read your statute definitions. Otherwise, you may make a mistake as far as what you thought was right and actually doesn't fit what your statute is. When we start talking about domestic violence, we have to always consider that, domestic violence doesn't happen in a vacuum in a lot of cases. There's events that lead up to that. And I've provided you a link where you can start looking at the cycle of abuse. This is just one of the websites that I found. But studying family violence, we need to really look at this in that we have the assault, the acute, what they call an acute explosion, hitting, choking, humiliation, whatever the bad event is, falls into here. Then, the abuser may be very apologetic, may buy gifts, beg forgiveness, no matter what. They're very remorseful at this point. But then we come over to here, and then the tension starts building up again. And we know that it's probably going to go back into this phase and this phase and this phase. As law enforcement, depending on how we respond to this call in our jurisdiction, that arrest may actually break this cycle. So you have to look at what your jurisdiction does and how you're trained as far as that goes. If you're a social worker responding to these families that are having this issue, finding a way through counseling or some other type of treatment to break this cycle of violence. But I provided that link. This is something that you will want to look at, and I would encourage you to study family violence, not only for people in relationships, but also children, the elderly, where we have violence in families, what are causes of it, and different things that we can do. So violence in the workplace, U.S. Department of Justice reports that each year 1 million people become victims of violence while at work. Think about the people that you work with. Maybe we don't like everybody. People bring their problems from home to work. People have mental illness, drug issues, all sorts of things that can go on in their personal life come to work with them. And if that work environment is, not necessarily a positive environment, people can, react violently. At the same time, maybe they've got an issue where they think everyone else is out to get them, and they're going to make a point with the use of violence. So that's something that we have to start thinking about. Obviously, we have violence in our school system, and, again, why are these people doing this? What are some red flags that we can look for when we start talking about violence in the workplace, violence in schools? Road rage, vehicle traffic-related injuries and deaths are the 9th leading cause of death worldwide, combined with the crime of driving while under the influence of alcohol, leading cause of criminal homicide in the United States. So road rage can include screaming at other drivers, honking without proper cause, murder. That's one of the issues that we had in our local area, not too many years ago. Cutting off other drivers with your vehicle, aggressive gestures, just that rude behavior because you've lost control of your emotions and you start saying or doing something. Or you respond to another driver that's doing the same thing. So, vehicle-related deaths and injuries are actions where criminal responsibility can be imposed. So, another crime against the person is known as road rage, and criminal charges can be brought for engaging in such behavior. This is a case that, from our local area back in 2018 where, a person has died as a result of road rage. So it's not, limited to big cities where there's a lot of traffic. It can even happen in our area. Okay, in addition to your text, remember you need to look at Chapter 10, read Chapter 10 and Chapter 14 of your Blue Book. And then I provided all these links as far as your lecture goes so that you can go and start getting this extra information. All right, that's it for this lecture.